What every Social Security disability applicant with cognitive impairment needs to know about steps 4 and 5 of the 5-step sequential evaluation. If you don't meet a listing, your entitlement to benefits will be determined based on the medical and vocational criteria at steps 4 and 5. At step 4, you have to show that you can't go back to the lightest, physically demanding, and simplest job you held in the 15 years before you became disabled, and there isn't any other work that you can do in the mythical national economy based on your age, education, skills, or residual functional capacity. When you apply for benefits, the Social Security Administration will look at your medical records to try to determine what your residual functional capacity is. Your residual functional capacity is what you can do despite your cognitive impairment. If they can't tell from a review of your records, they'll send out your file to a medical consultant who will render an opinion that you're capable of doing some level of work based on your cognitive impairment, and that will result in a claims denial. It is crucial, in my view, that you have your physician complete a residual functional capacity form. Now, your doctors probably don't know about these, and the Social Security Administration hasn't told you about these forms, but these are the key to getting your Social Security disability benefits. Your doctor should be asked to fill out a residual functional capacity form based on the underlying medical condition that's causing you the cognitive problems. And these questions that you'll find on these forms are, I think, crucial because they will help explain what it is you can and cannot do. So the form will ask your doctor what trouble you have with language and effective communication or speech, whether you have disruption of the use of your arms or legs that interfere with walking and the use of your fingers, hands, and arms. What are the changes in your cognitive abilities? Is there any disorientation or personality changes or mood changes that not only limit your daily activities, but your social functioning and your ability to concentrate? Has there been any reduction in your IQ? Do you have problems starting something and staying on task and finishing it in a timely manner? Do you have good days and bad days? And how many days per month would you miss from work? Do you have psychological problems such as anxiety or depression that would interfere with your ability to work? This isn't an exhaustive list of all the questions that you would see on a residual functional capacity form for brain injury or Alzheimer's or cognitive impairment. But hopefully you can see that having an explanation of what you can do physically, cognitively, and emotionally is the key to winning your case. Many cases are lost because the applicant didn't get that residual functional capacity form, or it wasn't properly completed, or their doctor said they weren't going to play ball. This is important because, as I started this video, I said there was another component, and that is the vocational aspects of your claim. If the Social Security Administration can't figure out what your residual functional capacity is at the initial and request for reconsideration levels, your claim is going to be denied. And that's a shame. But you're going to end up in front of a judge in a hearing. And at the hearing, the judge will determine your residual functional capacity. And they're going to turn to a vocational evaluator who will be testifying at hearing and asking questions about whether you can go back to the simplest job you held in the 15 years before you became disabled, and whether there's other work you can do in the national economy. So let's say the judge asks the vocational evaluator to assume somebody just like you can sit for 6 hours, stand for 6 hours, lift 10 pounds, and ask, can that person go back to the simplest job they held in the 15 years before they became disabled? Now that is a silly hypothetical because it doesn't include any information about your cognitive problems. And if the VE says, oh yes, judge, that person can go back to the work they did, you're going to lose. If the VE isn't asked additional questions about assuming the problems that you have from a cognitive standpoint, you're going to lose. And if the judge doesn't ask the vocational evaluator whether you can do other work in the national economy, you're going to lose. But let's say the judge does. Based on the hypothetical I just gave, do you know what's going to happen? That vocational evaluator is going to rattle off 3 dumb jobs, like working in a laundromat, folding laundry, addressing envelopes, or putting silverware in a cloth napkin and doing that all day. Nobody wants to do that, and it doesn't certainly pay a living wage, but that is enough to result in a claims denial. I really think you should have an attorney at all stages of a Social Security disability claim. The initial application, the request for reconsideration, and a hearing. Why? You don't understand the 5-step sequential evaluation. You don't know what's in your medical records. You don't know how to get the right residual functional capacity form. You don't know how to present your case to the Social Security Administration or a judge. And if you're in a hearing, you don't know how to testify, and you don't know how to cross-examine a vocational evaluator. The odds of getting your benefits are greater when you are represented by an experienced Social Security disability attorney such as myself. You are placing your Social Security disability money benefits and medical benefits at risk. So don't delay. Make the call. Cavey Law, 727-894-3188. depression.